Good morning. Today is August 4th of 2022, and the current time is 9 a.m. We are here for, is it day 4, I believe? Day 4 of the evidentiary hearing in file number EF-2022-0155, which is Evergy Missouri West's request to securitize certain costs related to Winter Storm Uri. My name is John Clark. I'm the regulatory law judge presiding over this. Also today, we have some commissioners. I believe Chairman Sylvie is currently present. Do we have any other commissioners present?
Good morning, Judge. Chairman Sylvie.
Good morning, Chairman. Other commissioners may be joining us throughout the day. At this time, I'm going to have counsel for parties enter their appearance for today. On behalf of Evergy Missouri West.
Morning, Judge. Jim Fisher, Carl Zobrist, Jackie Whipple, Roger Steiner on behalf of the company.
Staff of the commission.
Yes, excuse me. Yes, Judge. Appearing on behalf of the staff of the commission, Jeff Keevel.
Thank you. Public counsel.
Lindsay Van Gerpen on behalf of the Office of Public Counsel.
Thank you. MECG.
Tim Opitz on behalf of the Midwest Energy Consumers Group.
Thank you, and I'll note for the record that Velvet Tech Services and Nucor Steel requested yesterday to be excused from today's hearing, and that was granted, so they are not present. I wanted to go over a brief preliminary matter before we got going, and this is for staff. Yesterday on the stand, Ms. Lange indicated that she was working with Mr. Lutz on an exemplar tariff, which I believe is supported by the stipulation and agreement. Is that correct?
Yes.
And she also indicated that that might be completed before the end of the week. Is that correct?
I think that's what she indicated, but I don't know where they are. I don't know if that's come to fruition or not.
I know that may or may not have. Would it be possible to have that submitted as a late filed exhibit?
Oh, is a late file? Yeah. I don't see why we couldn't do that. Again, it may not be by tomorrow.
That would be fine if they can file it as a late filed exhibit, and I'll give a period of time to file written objections to it. Likewise, I believe during Mr. Ives' testimony, I had asked if he could provide some things as an exhibit. Can those things requested be submitted as late filed exhibits?
Yes, Your Honor.
Thank you very much.
Would you mind going over those? I have them in my notes if you don't have them handy, but
I believe, hold on just a second, and I believe I can. Lisa Starkbaum's direct testimony from ER 2022-0025, which is Evergy Metro's FAC. I also believe 2017 IRP annual update. I believe that is it. But if there's another that occurs to me, I will let you know.
okay.
Are there any other preliminary matters that need to be dealt with at this time before we go back into witness testimony? I see none. I believe we'd agreed yesterday to proceed with staff's witness Davis. Is that correct?
Yes.
Go ahead.
Yes, Judge, staff would call to the stand Mark Davis.
Would you raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you are about to give at this hearing is the truth?
Yes.
Please be seated. I'm going to ask that if you lean back from the microphone, your voice will disappear. So I'm going to ask that you speak into the microphone. Go ahead, staff.
Thank you, Judge. Excuse me. Sir, would you please state your name for the record?
Mark S.A. Davis.
All Are you the same Mark Davis who has caused to be prepared and filed in this case the rebuttal testimony of Mark Davis in both public and confidential versions, and which has been pre-marked as exhibit number 106C and 106P?
Yes.
Do you have any corrections or additions you need to make to that testimony?
Yes.
What are those?
On page 4, line 2, 302.8 million should be revised to 303.0 million.
And as I understand it, that correction is simply to coincide with the corrections Ms. Boland made yesterday to her testimony. Is that correct, sir?
That's correct.
Thank you. With that correction, if I were to ask you the questions contained in Exhibit 106C and 106P, would your answers be the same as contained therein?
Yes.
And are those answers true and correct to the best of your information, knowledge, and belief?
Yes.
Judge, with that, I would offer Exhibit 106C and 106P into the record.
Any objections to admitting Exhibits 106C and 106P onto the hearing record? 106C and 106P will be admitted onto the hearing record.
Thank you. Judge, with that, I would tender the witness for cross.
Any cross-examination from MECG?
No, thank you, Your Honor.
Any cross-examination from public counsel?
No, thank you, Your Honor.
Any cross-examination from Evergy?
No questions, Judge.
Any commissioner questions? I have a few questions for you, Mr. Davis. Would you briefly explain to the commission the process involved in structuring, marketing, and pricing the bonds once a financing order is complete?
Sure. Structuring, there's many elements to structuring, marketing, and pricing the bonds. Starting with the structure of the bonds, the goal of structuring the bonds is to put together various elements of the financing to ultimately obtain the lowest cost issuance. That could involve items such as reviewing and preparing registration statements to document the bonds with the SEC, reviewing and preparing rating agency materials, which would be necessary for marketing the bonds, as well as various elements of the bonds such as tranche structuring, determining the term and maturity of the bonds, or other features that would make the bonds most interesting or appealing to investors, such as index eligibility to enhance the liquidity of the bonds and make them more attractive to the investor universe. So ultimately, the structure of the bonds is designing an instrument that's most attractive to investors and as a result can help achieve the lowest cost. Moving to the marketing of the bonds. Marketing of the bonds is the process to obtain access to the lowest cost sources of capital possible. That oftentimes begins with the underwriter selection process. So bringing in underwriters, understanding the views across all of Wall Street of what would make the bonds most appealing to the broadest source of low-cost capital investment as possible. Again, oftentimes involving registering the bonds with the SEC, obtaining credit ratings and reviewing the amount of credit ratings or number of agencies required to obtain the best terms. The strategy in terms of how to get information necessary to investors to make sure that they have what they need in order to invest in the bonds, and the materials that would be shared with investors which could include items such as roadshow presentations, non-deal roadshow presentations, pre-recorded roadshow materials, rating agency presentations, and alike, to make sure that investors have the information that they need in order to understand the issuance and do the work they need to invest in the bonds. The marketing process also involves the time spent with investors, educating them on the process. It may kick off prior to formal announcement of marketing through events such as non-deal roadshows, educating the market on the securitization product that's going to be coming to market, followed by oftentimes roadshows during the marketing process, small group investor meetings or one-on-one investor meetings, educating individual investors on the issuance itself, as well as educating investors on the pricing of the bonds. So there may be discussion around what the relevant pricing benchmarks are and how the bonds ultimately should be priced. Moving to the pricing stage is effectively the strategy and process to bring pricing in as tight as possible for the bonds. And the goal within the, oftentimes within utility rate reduction bond statutes, is to achieve the lowest possible cost on the bonds. So pricing may involve reviewing pricing benchmarks, determining what pricing levels should be displayed to the market to drive interest into the bonds, and then a process going from those initial discussions with investors, which are oftentimes referred to as initial price talks or whisper pricing, through a guidance stage, which is an opportunity to further tighten pricing with the market if the investor interest is sufficient to justify it, ultimately to test pricing, which is a further opportunity to tighten up pricing and understand the level of investor demand in the book, and then ultimately locking in the treasuries and pricing the bonds themselves. So that's at least a high-level overview of many of the key elements of the structure and marketing and pricing of the bonds.
Thank you. I'm going to ask you some questions about at what point in the process certain activities occur, and would you tell me when those activities would occur or if they occur as part of the process? I know you indicated that selecting underwriters occurs under the marketing process. Is that correct? Are there meetings to select the underwriters or other deal participants?
The process for selection of underwriters can vary from state to state and from utility to utility. Oftentimes that process is defined by either the utility in advance of the financing order stage, or it may be defined within the financing order itself in terms of what process and involvement the commission and other part or designated representative or finance team may have in the process itself. Oftentimes the structuring advisor, who typically is the lead underwriter, is selected in advance of commission proceedings. That structuring advisor is involved in drafting the financing order and various elements of what goes into the utilities application. That party is oftentimes the lead underwriter, but there's oftentimes a process following approval of the financing order that may involve commission-designated representatives or finance teams to solicit proposals for lead underwriters, gain information across Wall Street of what underwriters may recommend the different elements of the structuring, marketing, and pricing of the bonds ultimately should look like, and use that information to ultimately select other lead underwriters beyond the structuring advisor to oversee the process, as well as, in the event appropriate, to select co-managers who are other parties that may help market the bonds. So in short, it could occur at the very beginning of the process prior to the finance order ultimately being approved. It could be ordered in the financing order to occur following approval of the financing order with input from the designated rep or other commission related parties to ensure that the information that's provided through the underwriter selection process is sufficient to help inform the designated rep of the various elements of structuring, marketing, and pricing as they proceed through the process.
Are you aware of whether an underwriter has been selected in this case?
I understand a structuring advisor has been selected, Citigroup. That structuring advisor would naturally take the seat as the lead underwriter, but it's my understanding they have not been formally retained as the lead underwriter at this point in time.
Just a second. At what point in the process would rating agency presentations or meetings occur?
Typically shortly after retention of the lead underwriter and potentially retention of other lead underwriters, the rating agency discussions would begin. So there would be selection of typically structuring advisor as the lead underwriter. Other lead underwriters may be added to that group, review rating agency materials. Rating agency materials may be reviewed and probably should be reviewed with the designated rep and its advisors before being shared with the rating agencies, but it typically occurs very early in the process. The rating agency process is one of the longest lead time components of the issuance itself. Typically takes 6 to 8 weeks to get through the rating agency process, and so oftentimes that occurs very early on, along with the SEC registration documents and associated documents, as to allow the rating agencies to do their work while the remainder of the finance team work and structuring occurs.
During this process, do regularly scheduled meetings or calls with the financing team or working group occur?
Yes, in processes where I've been involved, it's typical to have regularly scheduled meetings, as you've asked.
Is it unusual to have a designated representative at those meetings? Like a designated staff representative?
No, it's typical in the instances where I've been involved to have the designated rep and its advisors participate in the meetings throughout the process, beginning very early on at the underwriter selection process throughout the structuring, marketing, and pricing process.
At what point in the process do documents such as indenture servicing agreements, offering documents, purchasing agreements, marketing materials, and rating materials, at what point do those get distributed? And I know I've asked about a lot of different documents that probably have different distribution times.
The vast majority of the documents you've described would occur, again, very early in the process. And part of the reason for that is they're necessary for either SEC registration documents or rating agency reviews. So items such as the indenture, the servicing agreement, administrative agreement, all inform the rating agency review, and as a result are reviewed and distributed very early in the process.
Is it unusual to have a designated staff representative receive those documents for review?
No, in my experience, it's common for the designated representative to both receive the documents, review and comment on the documents before they're distributed to rating agencies and other third parties.
Do you have experience with similar securitization transactions to what's going on here?
I do. I've advised on over $8 billion of transactions completed this year, and I'm currently advising on similar transactions in 4 states, including this one.
And in your experience, what have other commissions done, or would you recommend this commission do to have the interests of the ratepayers represented during the marketing, pricing, and structuring phase of bond issuance?
It's typically spelled out in the financing order what role or involvement the commission or designated rep would have in the process. There's various elements of the process which are defined by the statute where the designated rep can be involved. There's other requirements within the statute, as I understand them, to achieve the lowest cost execution. And having full involvement from the very beginning of the process, at the point when the financing order is approved, throughout the structuring, marketing, and pricing, I believe is important to achieving the lowest ultimate cost of the securitization as required. So I would recommend the designated rep and its advisors be involved from the point the financing order is approved and have regularly scheduled meetings with the utility to work through the structuring, marketing, pricing, as well as review the upfront and ongoing costs as the process evolves.
Now, Evergy will have the responsibility regarding the structuring, marketing, and pricing of any bonds that would be issued. Should the commission's financing order specify minimum activities during the structuring, marketing, and pricing of bonds that input and collaboration with the commission's designated representative should be required?
Could you repeat the question?
You had indicated in your answer to my previous question that you believe that levels of involvement of the designated representative vary depending upon financing orders and by statutory allowances. And while it's understood that Evergy will have the responsibility regarding the structuring, marketing, and pricing of the bonds, do you think that a financing order should specify at a minimum activities which the commission's designated representative and, as you said, financial advisors should be required to participate?
I do, or in other words, they should have the opportunity to participate. The designated rep should have the opportunity to participate in those various elements or other elements at the time working through the process they deem to be appropriate. Ultimately, what's very important in the review process is making sure that the structure, marketing, and pricing are set up in a way where ultimately there's no need to reject the issuance advice letter at the end of the process. If the issuance advice letter is rejected, that could be catastrophic to the ability to issue rate reduction bonds in the future in the state. And so defining a process which ensures there's involvement throughout the process can both prevent the issuance advice letter from ultimately being rejected and provide an opportunity throughout the process to ensure that each element is structured in a way to achieve the lowest cost.
And do you believe the level of involvement of the designated representative should be defined in the financing order?
I believe the financing order should lay out certain items that the designated rep should opine on, like the structure and marketing and pricing, and the degree of interaction they should have with the utility. Should they provide, input and collaborate? Should they have rejection rights? The degree of authority granted to the designated rep in each aspect of the process should be defined in the financing order.
Should the commission require that Evergy, the underwriters, and an independent financial advisor deliver to the commission independent written certifications without material qualifications confirming what they have done has in fact resulted in the lowest cost of funds and lowest recovery charges consistent with market conditions at the time of bond pricing?
So I believe both the issuer and the underwriters should deliver certifications to the company that have a conclusion without material qualification that they've achieved the lowest cost consistent with market conditions at the time. Underwriters may require various assumptions to go into how they arrived at that conclusion. For instance, information that they've relied on from the company is something they need to rely on and not independently diligence every aspect of the information they've received. So the certifications, the stronger they are from the underwriters and issuer, are more valuable, but they need to be structured in a way that does not preclude a large portion of the underwriter universe from participating in the issuance. The underwriters are very important to ultimately achieving the lowest possible cost, and so ensuring that there's a sufficient pool of available underwriters to participate in the issuance is also an important element of achieving the lowest cost.
In your experience, what conditions or requirements are underwriters typically willing to certify to?
In my experience, the underwriters will provide a conclusion that based on the steps that they've taken, the scope of their engagement, and the assumptions that they've relied on, that the issuance, including the structuring and marketing and pricing, result in the lowest cost consistent with market conditions at the time. So they'll qualify to some extent with the assumptions and the scope of their role, but they'll ultimately come to a conclusion that based on those inputs, that they certify that the structure and marketing and pricing achieve the lowest cost.
Are there things that underwriters will not certify to?
I'm sure there are. I couldn't delineate exactly what those items are, but in the event it's a fully unqualified opinion without any limit on the scope of the underwriter's involvement or the assumptions they've made, underwriters may not be willing to issue a certificate under those circumstances.
In regard to repayment schedules, expected interest rates, and financing costs, both upfront and ongoing, what will be the parameters of the bonds, establishing the terms and conditions of the bonds?
The proposed financing order maintains a good amount of flexibility for ultimately what the repayment schedule looks like and interest rate schedule looks like.
Can you repeat that? I'm sorry.
The proposed financing order retains a good amount of flexibility as to what various elements of the ultimate issuance looks like including the repayment schedules, as well as the term of the bonds and the interest rate of the bonds. Many of those elements won't be known until the process is completed. As an example, the term of the bonds is proposed in the financing order to be 15 years. However, the proposed financing order also maintains the flexibility to make adjustments to the extent necessary to achieve the best possible credit rating. Achieving that best possible credit rating is important to achieving the lowest cost. So in the event the term, as an example, needed to change in order to achieve the lowest cost, that the flexibility to modify the term is helpful to retain within the financing order.
Could I, I'm a little bit, whether you or whether Mr. Davis were talking, when you're talking about the proposed financing order, whether you're talking about the financing order which has been proposed in this case so far by Mr. Lund, or whether you're talking about a as yet to be proposed financing order.
I am talking not about a specific financing order. I am talking about in general, how a financing order might work. So not a particular proposed one, not Evergy's proposed one, not the one that staff may do, but I'm speaking generally of financing orders.
With that, to clarify my answer, I was describing the financing order described by Mr. Lund. Financing orders can vary widely in terms of ultimately the structure that's proposed. If there's a defined term, which may be the commission may determine is appropriate from a policy perspective, intergenerational transfer, affordability perspective, that may be defined in a financing order, or may be left open ultimately to achieve the lowest cost based on the bonds that are, or the term appropriate to achieve the lowest possible cost, as reviewed in the future by a designated rep. Repayment schedules are oftentimes left open within a financing order, as the interest rate is unknown, and the interest rate, given the levelized payment nature of securitization, informs what repayment schedules look like. So that's oftentimes left open and ultimately provided to the commission through the review process and in final form in the issuance advice letter. And the interest rate remains open. In some instances, there's a cap on the interest rate if required by the statute, but oftentimes the interest rate remains open, reviewed by the finance team, and ultimately approved by the commission through the issuance advice letter process.
Should a procedure be established that allows or requires staff to audit the ongoing financing cost post-issuance of the bonds? And that would be inclusive of such things as servicing fees, return on invested capital, accounting fees, legal fees, rating agency surveillance fees, and indenture trustee fees? And to shorten the question, should staff be allowed or required to audit those?
Staff should be allowed to audit those amounts. In finance team roles where I've been involved, various elements of items such as a servicing agreement, an administrative agreement, so portions of the securitization proceeds that are paid directly to the utility, are oftentimes required through the finance team review process to be reviewed to ensure that there's no double collection by the utility on items such as servicer fee or administrative fees, with true-ups or adjustments taking place through the general rate cases. So oftentimes there is a subsequent review, and credits back to utilities in the event, or back to the ratepayers in the event a utility is over collecting on items such as servicer fees or administrative fees. So review process, I believe, would be appropriate, with one caveat that it shouldn't limit the amount that the utility collects or the SPV collects on account of the securitization vehicle. It needs to be known how much the securitization vehicle will receive in order to keep that entity separate from bankruptcy, from a bankruptcy perspective. But the adjustments or auditing could take place separately, as long as it doesn't impact the cash flows available to the securitization vehicle itself.
Are provisions allowing or requiring staff to audit unusual, or have you seen those before?
I've seen provisions where amounts that have been collected in excess of actual costs get credited back to ratepayers in a general rate case. I'm not familiar with instances where there's a separate audit of costs, but I also don't see that being problematic.
Now, in Evergy's proposed financing order that was attached to Lundy's testimony, direct testimony, it allows for the issuance of securitization bonds in one or more series, with a financing order to be issued at the issuance of each series of bonds. And at page 17 of his direct testimony, he states that he expects the bonds to be issued in 2 or 3 tranches to target specific investors, but he doesn't provide a similar expectation that the bonds would be issued in multiple series. Would you please explain to the Commission how the issuance of multiple series would work?
I would say it's uncommon for securitization bonds to be issued in multiple series. I've seen it done before. I've been involved in instances this year where it's taken place in multiple series, but that's been driven by the overall size of the offering. In this instance, given the size of this offering and the amount of fixed costs associated with securitization, I would anticipate it to be unlikely that the offering should take place in multiple series. It should be reviewed by the designated rep or finance team during the pre-issuance review process after the financing order is put together, and evaluated in conjunction with the review of the upfront and ongoing cost to see if it would be prohibitively expensive to issue the securitization through multiple series. Ultimately, if the underwriters aren't able to place the full amount of the bonds in a single series, having the flexibility to issue incremental bonds through a subsequent series rather than pull a deal may be advantageous to have the flexibility for. However, I would anticipate in this instance it to be highly unlikely that multiple series would be appropriate or should be pursued in this instance.
Under what circumstances would it become necessary to issue multiple series?
In the event the underwriters would be unable to place the full amount of the bonds at the lowest possible cost, a portion of the bonds may be held back to be issued in the future. However, an analysis would need to be completed to determine if the incremental fixed cost associated with a separate series of bonds would justify withholding a portion of the bonds from issuance as part of the first series.
If multiple series were issued, what would that mean about the number of financing orders that would have to be issued?
I've seen multiple series of bonds be issued under the same financing order in the past. So a financing order approved the ability to issue the bonds in one or multiple series. The utility would need to file multiple issuance advice letters with the commission. However, it would be uncommon to require an incremental financing order to issue the second series of bonds.
If the commission were to approve a financing order allowing multiple series, what would that mean in the process if multiple financing orders are required?
Could you clarify your question?
I can try. You said that you have seen where a single financing order authorized the issuance of multiple series. Is that unusual?
No, it's not.
Would it be more usual to see multiple financing orders if there are more than one series issued?
I haven't seen that before.
You haven't seen multiple orders?
No, not for the same same cost being sought for approval. I've seen multiple financing orders in the event a portion of the costs haven't been incurred yet. So under the same statute, seeking additional authority to securitize incremental amounts once they had been incurred and approved by the commission. However, I haven't seen an instance where amounts had been incurred, approved by the commission, and separate financing orders were issued, separate financing orders were required to securitize the balance that was approved for securitization.
How would multiple series impact the financing costs from the issuance of the bonds at different times? If, assuming more than one series.
Multiple series are likely, if not, would almost certainly increase the financing costs associated with the issuance. And that's driven by a large amount of fixed costs associated with each issuance. So items such as legal fees, rating agency fees are fixed costs, and on an ongoing cost basis, items such as administrative fees or accounting fees are oftentimes a fixed cost that would be incremental in the event of multiple series. So all costs aren't variable. There's a portion of the costs that are fixed and would be incurred for each series of issuance, resulting in an increase in the overall costs.
Assuming for a moment that two series would be issued, how would the cost of issuing a second series be recovered?
It's my understanding that the cost of a second series would also be recovered from ratepayers as a line item on the ratepayer bill.
Is that any different from how a single series would be recovered?
No, I would expect it to be recovered in a very, very similar way. It may be under the same line item It's probably under a separate line item on the customer bill, but otherwise, same mechanic to recover such amounts.
Does the issuance of multiple series impact carrying costs?
Yes, the upfront carrying costs would be different. There would be incremental upfront financing cost incurred from over the incremental time required to issue the second series of bonds.
So that's how it would impact the upfront financing costs?
That's one way it would impact the upfront financing costs. In addition to that, there would be legal fees. There's going to be separate registration documents filed. There's going to be separate ratings required. So upfront fees to the rating agencies. Certain other upfront costs may also increase, as not all those costs are variable or tied to the amount of securitization finance that's raised. Securitization finance that's raised.
What about ongoing financing fees?
Certain of the ongoing financing fees are also fixed, and so incremental amounts would be incurred on the second series of bonds. Fixed ongoing financing costs, as an example, would be items such as the administrative fee payable to the utility, accounting fees, as there's likely separate accounting required for the incremental series. A large portion of the ongoing costs, such as the servicer fee, are variable, so they're tied to the amount, so your servicer fee probably doesn't increase. But a certain number of those items, like the accounting fee and administrative fee, are likely to increase with multiple series.
Now, Lundy indicated that he had structured in his proposed order a scheduled final payment date for the bonds at 15 years and a legal final maturity date of 17 years after closing. And one of the reasons he gave for that later maturity date is to allow a period of time in which securitization charges can be collected to make up for any shortfall in the 15-year collection period. So what is the term of the bonds? Is it 15 or 17 years or both?
The maturity that investors will focus on is the 15 years, the scheduled life of the bonds. The pricing will be focused on that 15-year time period. The benchmark interest rate would be focused on that 15-year time period. The 17 years, or incremental 2 years, is incremental time that's provided to provide rating agencies and investors comfort that there won't be default if there's under collection on the principal amount of the bonds. It provides incremental time to collect in an event that proceeds have been insufficient to pay off the bonds through their scheduled final maturity date of 15 years. The tranche structuring will be designed to achieve that 15-year stated maturity, but in the event there's not enough collections during the final periods to pay off the bonds by year 15, there's incremental cushion to continue to collect the charge as necessary to pay off the bonds before that stated final legal maturity date of 17 years.
Do you have Lundy's proposed financing order?
I do.
I'm going to ask you some questions about that. On page 38 of that order, in paragraph 69, let me know when you're there.
I'm there.
Did you say page 38, paragraph 69?
Yes.
Because I noticed that there is, at the top of Mr. Lundy's schedule, there's a different pagination than on the bottom of Mr. Lundy's schedule. So if you look at the bottom pagination, it's actually page 40, I think, instead of page 38 that paragraph 69 appears on. But if you look at the top of the page pagination, it's page 38. So I just want to make that clear that we're all looking at the same pagination here when we're talking about it. Am I correct there that that's the one you're looking at?
Yes, I'm looking at, I believe paragraph 69 provides that the commissioner or its designated representative can require a certificate from the company. Are we all there? That's it. I want to pick up for just a second, and you mentioned earlier that the financing order submitted by Lundy provides a level of flexibility in terms of the bond. In that document, it references 15 years as the terms of the bond. Is it your understanding that under the financing order, the issuer would be able to issue the bond for more than 15 years, or even more than 17 years for the legal maturity date proposed?
Yes, I recall there being language in the financing order, and I actually see it here on paragraph 73, I believe, on the following page, that indicates unless deemed that the 15 years or 17-year final legal maturity is that amount, unless deemed necessary to obtain the best possible credit rating. And so there's incremental flexibility to move that term if necessary, as proposed by the issuer.
Have you seen those kinds of terms applied before, where a bond final payment or where a bond term is changed?
Yes, I've seen similar flexibility built into other financing orders to allow the term to ultimately be set during the post-financing order pre-issuance review process.
But you don't believe that provision is unusual?
No, I've seen it used in other instances.
Okay, let's go back to paragraph 69, which allows, as I said, the commissioner or designated representative may require a certificate from the company, for which the company will rely on a certificate from each book-running underwriter confirming that the structuring, marketing, and pricing of the securitization bonds resulted in the lowest securitized utility tariff charges consistent with market conditions. Have these certificates been delivered in other utility securitizations?
Yes, that's my experience.
What information or statements would the book-running underwriters provide so that the company can make such a certification?
In many instances, I've seen the certification not only be provided to the company directly, but also a certification be provided to and for the benefit of the commission. And so in my experience, there's value in both the issuer receiving the certification, but also the commission getting the benefit of the certification itself. Part of the benefit of the commission receiving the certification is also the ability of the commission staff's designated representative to evaluate the terms of that certificate, the assumptions that are made, qualifications, if any, that go into the certification, to make sure the certification is appropriate and the underwriters feel an obligation to achieve the lowest possible cost on the financing itself.
And what I heard there was there are instances where you've seen the requirement that the underwriters provide certification directly to the commission. Is that correct?
Correct.
Should the financing order include a form of underwriter certification together with the form of the issuance and advice letter?
That would be uncommon based on my experience. The certification oftentimes outlines the process necessary or the process that was undertaken in order to achieve the lowest cost. And that process may evolve based on the market conditions at the point in time when the underwriters are structuring, marketing, and pricing the bonds. And as such, I've typically seen the certifications be developed during the process and reviewed by the designated rep or finance team, but not be structured and rigid in advance of the process itself unfolding.
And just to follow up on that for a second, if that's not required, and instead the underwriters certify to the company and then the company certifies to the commission, does the company then control the language of the certification? That's provided to the commission?
They may. It doesn't appear to be defined in paragraph 69 how that process would work.
Do you believe that the designated staff representative would be involved in that part or not?
I believe it would be helpful to the process to have the designated rep involved in review of each of the certifications, both those of the underwriters as well as those of the issuer. I could see the issuer require the underwriters to provide certifications that are very close to the certifications the issuer is providing directly to the commission. However, involvement, review, input over both the underwriter and the issuer's certificate, I think would be appropriate.
Say that last sentence again, please.
I believe involvement or oversight into the certification of both the issuer and the underwriter's certifications would be appropriate.
Lundy's proposed financing order indicates that the commission or its designated representative may participate with the company in discussions regarding the structuring and pricing of the securitized utility tariff bonds and provide input to the company and collaborate with Evergy West in all facets of the process taken by Evergy West. Would that participation include the meetings to select the underwriters or the other deal participants?
I believe that it's appropriate to include the selection of underwriters and other deal participants in that review process. It's unclear from the proposal that Evergy's provided on what degree of involvement they're envisioning as part of that process.
Would that include participation in rating agency presentations or meetings?
I'd provide the same answer.
Would the designated representative participate in regularly scheduled meetings or calls of the financing team or working group?
Same answer on that topic as well.
Should staff's representatives and advisors be included in the distribution of documents? And I believe these are documents I mentioned before, indenture, servicing agreements, offering documents, purchase agreements, marketing materials, and rating materials?
Yes, it's appropriate for the designated rep and its advisor to receive and have an opportunity to comment on such documents.
Now, on page 37, and at least I hope we're talking about 37, and I'm looking at provision C14, non-standard true-up provisions.
I'm with you.
Would you explain what a non-standard true-up provision is?
Oftentimes, non-standard true-up provisions are provided for in financing orders to provide flexibility to deal with changes in customer classes over time. So for a long-term financing, if customer classes evolve, to deal with equity issues associated with those or other unknowns when the financing order is entered into, there's flexibility to modify the way that the revenue is collected or the customer classes that they're allocated to deal with such equity issues. Making such modifications typically would require approval of all parties, including commission, rating agencies, the utility itself. So it provides incremental flexibility to make modifications if required in the future, but also is limited in terms of the ability to use it, as any party could reject use of the non-standard true-up as required. I would note the staff's proposed allocation of the rate reduction bonds on a per unit basis rather than by customer class reduces the likelihood that a non-standard true-up or use of a non-standard true-up would be required in this instance.
And under what circumstances would a non-standard true-up provision be applied? You said that staff's loss-adjusted allocation, is that correct? Minimizes the potential for that? Under what circumstances would the non-standard true-up provision be applied?
If instead the customer class allocation were broken down into multiple customer classes, and one of the customer classes was reduced to, a single customer or eliminated, having the same allocation to that customer class may not be appropriate, and so a non-standard true-up to adjust for that could be appropriate.
Are there other circumstances where you could see that being applied?
Sitting here today, nothing comes to mind.
Now, this non-standard true-up provision, would you say that it's typical for securitization financing orders?
Yes, it's common to see a non-standard true-up provision.
Would you turn to Schedule SL4 in Lundy's SIR rebuttal? And that's where he does his break-even analysis.
Did you say SIR rebuttal?
That is correct.
Okay, I'm with you.
Now, in that table, he included a break-even analysis for the net present value calculations comparing securitization to both an FAC and a accounting authority order. Would you explain the results of his analysis?
Yes, as presented by Mr. Lundy, and using the assumptions that Mr. Lundy used around the carrying cost under customary rate making, he derives a break-even interest rate of 9.72% for securitization relative to an AAO method and 6.986% for securitization compared to an FAC method. So that's the maximum interest rate based on all the assumptions that Mr. Lundy assumed that would result in savings relative to the customary method as he's presented them.
And those rates you just put forth, those would be the maximum coupon interest rates?
Correct.
Do you have any idea how those rates would change if the commission approved Evergy's long-term rate of 5.06 for both the carrying costs and the discount rate instead of the weighted average cost of capital?
I can tell you directionally they would go down. They would go down. However, the quantum of change, I can't quantify sitting here today. We'd need to run his model with the revised carrying cost rate.
So, and just bear with me, I'm not a finance person. When you say go down, do you mean the break-even point gets better or worse?
The break-even point gets worse. It would be a lower securitization rate would be, the break-even rate for securitization would be lower than what he's presented.
Okay, better and worse may not have been the best term, but you said it gets, the break-even point is lower.
Correct.
So the maximum coupon interest rate would decrease.
Yes, assuming I understand your question correctly, which is the carrying cost under traditional rate making on a go-forward basis, post-January 2023, would be at 5.06% rather than the utility's weighted average cost of capital. So there's two components of carrying costs that have been evaluated. One, the carrying cost between Winter Storm Uri occurring and securitization, and then secondarily from the point when this is securitized or put into an FAC or AAO, going forward through the recovery period. And what I've been describing is that go-forward period, the rate coming down.
Do you know what percentage of costs Evergy is seeking to recover through its proposed financing order?
Evergy is seeking to recover 100% of costs through its financing order.
Under Mr. Lundy's evaluation, is the net present value of securitization better than that of an accounting authority order?
Yes.
Under his calculations, is securitization better than running these costs through an FAC?
Yes.
So in either scenario, the collection of 100% of the cost still results in a lower rate for the customer than an FAC or an AAO.
That's correct based on the assumptions driving Mr. Lundy's analysis, including the use of the weighted average cost of capital as the go-forward carrying cost under both of the customary rate-making methods.
Have you read Boland's, staff witness Boland's rebuttal?
Yes.
I'm sorry, rebuttal.
Yes.
Now, she references that you calculated staff's proposed estimated upfront financing costs. Is that correct?
Yes.
Now, I didn't see in your testimony how you calculated that number. Would you explain how you came up with that number?
Yes, the estimated upfront financing cost supporting my testimony relied on the company's estimated upfront costs adjusted to take into account the reduced amount of costs staff proposed being securitized. So variable costs were reduced, reducing the amount of the upfront fees. The balance that I calculated also excluded commission advisor costs, which would be payable in the event securitization is approved or not approved, to provide for a similar comparison or apples to apples comparison between securitization and a non-securitization case.
Have you done a calculation that would include staff's advisor costs?
No.
Okay, thank you. Those are all the questions I have for you right now. Any questions based upon bench questions? MECG?
Very briefly, Your Honor. You were discussing non-standard true-up provisions with the judge. Do you remember that?
Yes.
And you were talking about circumstances where the non-standard true-up would come into play. And one of your examples included if there was one customer on a class and they left the system, that might cause a non-standard true-up. Is that accurate?
Correct.
But having a allocation on a class basis wouldn't in itself cause a non-standard true-up?
Correct. It's not necessary simply because there's multiple classes. It's if something changes materially within the class.
Okay, thank you.
Any questions based on bench questions from public counsel?
No questions, Your Honor.
Any questions based on bench questions for Evergy?
Yes, Judge, just a few questions here. Mr. Davis, I believe that you said in your initial remarks that you understand that Missouri is like other states and that we are governed by the statute that the legislature passed with regard to securitization, correct?
I don't recall being asked that's a question.
Well, we are governed by a statute that everyone here, including you and staff and the company, are required to abide by. Isn't that true?
That's my understanding, yes.
Well, and in the other states where you have provided advice, you adhere to the statute in that particular state, correct?
Correct.
Okay. And like all of us here, you are obligated to follow in this case, it's section 393.1700, correct?
Correct.
And are you familiar with the non-unanimous stipulation that the company entered into with staff earlier this week?
I am.
Okay. And I'm assuming you are comfortable with the language that is included in that non-unanimous stipulation?
Yes.
Okay. And as you sit here today, is there any provision or phrase or sentence in that non-unanimous stipulation agreement that you object to?
No.
Okay. And I believe in the non-unanimous stipulation, there is language that is consistent with and indeed quoted in section, we call it little section H. It's 2, paren, 3, close paren, paren, little h, close paren. Do you recall that? It's the one that deals with input and collaboration and attendance at meetings, that sort of thing?
Yes.
Okay. And in fact, there is specific language in Missouri that states that the commission shall have the authority to designate a representative or representatives from commission staff who may be advised by a financial advisor or advisors contracted with the commission to provide input to the utility and to collaborate with the utility in all facets of the process related to the placement of the utility tariff bonds to market, correct?
Yes.
And am I correct that it does not include any right to reject certain aspects of this process in terms of the designated representative of staff? Is that true?
Is your question an interpretation of that section of the statute?
No, sir. My question relates to your use of the term rejection rights in response to one of the judge's questions about having input into the financing order. So if I could rephrase the question, am I correct that the statute does not provide a designated representative with the right to reject any aspect of the process in providing input or collaboration?
It's my understanding that the statute provides the commission with the ability to implement what's necessary to achieve the lowest cost. And if it viewed the role that it grants to the designated rep as necessary, or a finance team, as it designates, necessary in order to achieve the lowest cost, that it could implement such protections.
Sir, is there any language in this portion of the statute that allows the commission to delegate its lawful authority to a designated representative to reject, for example, the language in an underwriting certificate? Underwriter's certificate.
And you're referring explicitly to that subsection H, is that correct?
In this context, that's correct.
Mr. Zorbas, it sounds like you're asking Mr. Davis to draw a legal conclusion.
Well, Judge, I'm asking him where the right to reject, and he talked about rejection rights in his response to you. I'm asking if rejection rights are included either in section 2, 3H, or anywhere else in the statute to his knowledge. I'm just asking.
Okay, so
him-
you're just asking him if he sees that in the statute?
Correct.
Okay, why
correct.
don't we limit it to that?
Thank you.
Could you repeat the question with that in mind?
Sir, you remember that you used the words rejection rights, correct?
Are you referring to the description I gave around roles designated reps have in, or finance teams have in other instances?
Yes.
Yes.
Where, okay, and So you do find the language concerning rejection rights in the statute?
I believe that's a gross mischaracterization.
Okay.
What he just said.
And I apologize if I misunderstood. When you said yes, I wasn't sure what
I'm
you
going
meant.
to paraphrase and see if we can get here. Do you see anything about rejection rights in the statute using the term rejection?
I don't see the term rejection in the statute.
Thank you.
Thank you, Judge.
Does that get to what you wanted?
That's really what I was trying to get. Well, and the point of distinction was the commission certainly has lawful authority, but the designated representative in the statute is not given rejection rights.
Judge, the
I'm just
statute
wary
says
'cause-
what the statute says. If Mr. Zobrist wants to argue who has what rights, he can certainly do that in his brief, but this is not the time or the place for Mr. Zobrist to be testifying regarding the statute.
I think, did you have more questions on this, Mr. Zobrist, or was that it?
I think I got the response that I wanted, Judge. And
Okay, I think we are where we are. I think you've made your point, and that was the point I'm getting to, which is he can't interpret that statute.
all right.
You're not a lawyer, are you, Mr. Davis?
I'm not.
Let me ask you something about a phrase that you used when the judge was asking you about what happens during the pricing stage. You talked about the goal of achieving the lowest possible cost. Do you recall that?
Yes.
Am I correct that a standard of reasonableness is to be applied as you go through your recommendations and go through your analysis of what are the pricing terms, conditions of the bonds? It's the reasonableness of the terms. It's not that it's the lowest possible cost, whether it's reasonable or unreasonable. Is that fair to say?
Judge, I believe Mr. Davis was referring to the lowest cost provision of the statute. Again, God forbid we go back to that, but the term lowest cost, I believe, shows up in the statute. I believe that was what Mr. Davis was testifying about when he said what he said about lowest cost. And I think Mr. Zobrist is just mischaracterizing Mr. Davis's prior testimony.
Judge, I'm really not trying to characterize it. I'm just trying to understand it.
What's your question again for me?
To the witness, Your Honor?
I just want to know what your question is. I was
Okay.
trying to think back to what it is to
Okay.
try and deal with the objection first.
My question with regard to the costs that would be embodied in a proposal, the designated representative is to provide the commission with an opinion on the reasonableness of the pricing terms and conditions of the bonds. Is that fair to say?
Hold on a second, let me think about that. Does this get to whether he sees the word reasonable in there, or whether he believes that the term implies reasonableness?
I'm simply reading the statute and asking him if his testimony with regard to the lowest possible cost is consistent with the reasonableness of the pricing terms and conditions of the bonds that we see in Section 23H.
Hold on just a second while I get there.
He said lowest possible cost.
Bear with me just a moment. Why don't we just shorten my looking for it and you read it to me?
I'm sorry, Judge.
I said, why don't we just shorten my looking for it and you read it to me?
Read the phrase I was asking the witness about.
Yes.
In providing input to the utility, Mr. Davis, and collaborating with the utility in all facets of the process undertaken by the electrical corporation to place the bonds to market, so the commission's representative or representatives can provide the commission with an opinion on the reasonableness of the pricing, terms, and conditions of the bonds on an expedited basis.
Judge, I thought you asked Mr. Zobrist to read you the statute that he was quoting.
Oh,
I
It
did.
sounds to me, was I wrong with that?
No, you are not.
Thank you.
okay. That I
Would you read the section of the statute you're asking about?
Yes, sir. Yeah, it is sentence 2 in section point 2, paren 3, close paren, little h. And it states, the commission shall have the authority to designate a representative or representatives from commission staff who may be advised by a financial advisor or advisors contracted with the commission to provide input to the electrical corporation and collaborate with the electrical corporation in all facets of the process undertaken by the electrical corporation to place the securitized utility tariff bonds to market so the commission's representative or representatives can provide the commission with an opinion on the reasonableness of the pricing, terms, and conditions of the securitized utility tariff bonds on an expedited basis.
And what was your question again regarding reasonableness?
My question was just to confirm Mr. Davis's understanding that that opinion relates to the reasonableness of the pricing, terms, and conditions of the bonds. Is that correct, Mr. Davis?
Well, wait a second. What's your objection?
Well, for one thing, I don't know what this has to do with the bench questions. For another thing, I don't believe Mr. Davis quoted mischaracterizing Mr. Davis's previous testimony is my basic objection here, but it's also beyond the scope of your questioning, and it's ignoring other subsections of the statute that are in play. So
Judge, my response to Mr. Keevil is, yes, there are other sections of the statute that are relevant. I was just quoting this one sentence because it deals with the role of the designated representative.
I'm going to sustain the objection.
Mr. Davis, am I correct that the designated representative doesn't have the right to select the underwriter?
I don't believe the role of the designated rep has been defined.
Are you stating that the designated representative has the right to select the lead underwriter or other underwriters?
Are we talking about the statute, or are we talking about the Evergy's proposed order?
At this point, I'm just asking the witness for his opinion, Judge.
Go ahead.
Could you ask the question again?
Yeah. Do you believe that the designated representative has the right to select the underwriter or the lead underwriter for the securitization?
I don't believe the role of the designated representative has been defined.
Okay. But you do understand that the designated representative has the right to provide input and to collaborate with the electrical corporation, correct?
I understand certain portions of what the designated rep can do have been defined by statute.
And am I correct that the designated representative does not have authority to direct how the electrical corporation places the bonds to market? Is that correct?
I understand there's specific language within the statute around placing the bonds to market, although what placing the bonds to market means is not defined.
Are you familiar with the statute, what it says about the meetings that the designated representative has the right to attend?
Yes.
Okay. And it has the right to attend all meetings convened by the electrical corporation to address placement of the bonds to market. Is that correct?
Yes.
Okay. It doesn't say anything about the right to attend meetings that the electrical corporation has with rating agencies, does it?
My understanding is there's room for the commission to define the role of the designated rep within the statute. However, I don't believe that portion has been defined, but could be defined in the financing order itself.
Okay. Isn't it unusual to have a designated representative in rating agency meetings that the electrical corporation might have?
Are you asking about attending the meetings in person with the rating
Yes.
agencies?
Yes.
Yes, in my experience, a designated rep hasn't attended the meetings in person with the rating agencies, but rather had access to all information in advance of it being shared with the rating agencies and access to the information that came out of such meetings.
Is it fair to say that the underwriter's certification process is fairly standard in what it provides in securitizations?
I don't know if I can say that it's standard. I think it's different in each transaction.
What did you include for staff and commission advisor fees as far as upfront financing costs?
Beyond the scope of Ben's question.
Say that again. And Mr. Keevil, remember to lean into the microphone.
Sorry. He's getting beyond the scope of Ben's questions, asking about, I'm not even sure where he meant to include, but he just asked Mr. Davis what he included for advisor fees and upfront financing costs without designating where he was referring to having included them. And I don't remember that being part of your question.
I did in fact ask about whether or not he had calculated advisor fees in his upfront financing costs, I believe. I'm going to go ahead and allow him to ask the question. Your objection's overruled.
Could you repeat the question?
Yeah. Did you include for...
Please lean into the
Yes,
microphone.
yes. Thank you, Judge. Did you include for staff and commission advisor fees as part of upfront financing costs that you estimated in the securitization?
The review of commission and staff costs wasn't necessary for the analysis that I prepared.
So you did not include any fees in your analysis with regard to upfront financing costs?
My analysis, in order to compare apples to apples securitization to non-securitization cases, in both instances where fees are payable under the statute, they were excluded from the comparative analysis between the two cases.
Okay. Now, with regard to meetings, I think you agree with me that the law says that the designated representative gets to attend meetings that are convened by the electrical corporation with regard to the placement of the bonds, correct?
I understand there's provisions within the statute related to certain meetings that the designated rep is explicitly allowed to attend.
And am I correct that there's no power of the designated representative to call meetings and request or compel others to attend?
Are you asking about what's provided for or explicitly outlined in the statute around the responsibility?
Yes, sir.
I haven't seen provisions in the statute that explicitly address that concept.
Okay. And the underwriting opinion typically does provide an opinion on the reasonableness of the pricing terms and its conditions. Is that correct?
Can you clarify which underwriting opinion you're referring to? Are you referring to what's provided for in the financing order, the statute? Can you describe what you're asking about?
In the statute?
I don't know offhand what it says.
Just a moment, Your Honor. Am I correct that there is no concept called the finance team with regard to advising the commission in the statute per se? The words finance team are not in the Missouri statute.
My understanding is the Missouri statute provides flexibility for the commission to determine what provisions are appropriate to achieve the lowest cost. However, I haven't seen the language finance team outlined in the statute.
Okay. Judge, that's all I have. Thank you.
Thank you. Before we redirect, Mr. Davis, did you do a net present value calculation based on based upon staff's position for the amount to be securitized, carrying costs, and discount rate?
Yes.
Where would I find that calculation?
The output of the calculation is summarized in my rebuttal testimony.
What about the calculation itself?
I submitted work papers with the underlying calculation.
Are those attached to your testimony?
No, work papers are not attached to testimony. Schedules are attached to testimony. The work papers are provided to all the parties at the time, I think within 2 business days of filing the testimony. But the work papers themselves, I don't believe are attached, unless there are schedules to Mr. Davis's testimony. They're not attached, and we can certainly file them if you want us to.
I would like you to submit his net present value calculation work paper as an exhibit, if you don't object to that.
Net present value calculation, was there something else?
I don't want the outputs. The outputs he's indicated are already in testimony. I'm curious about the calculation. I can see, at least to a large degree, Lutz's. And if you can file that as a late filed exhibit, I'll provide time for the other parties to file objections to that as well.
Okay, we certainly can.
I will consider that a question, so I'm just going to allow real quick. Does MECG have any questions based on that?
Oh, thank you, Judge.
OPC?
No, Your Honor.
Evergy?
None, Your Honor.
And you don't have any further questions this time, Evergy, correct?
I'm sorry, that's correct, Judge.
I believe you already said that. Staff, any redirect?
Well, I feel obligated to, after Mr. Zobrist's recitation of statutory language. Mr. Davis, Mr. Zobrist asked you several questions about what he referred to as sub H, I think, of the statute. And I'd like to draw your attention, if I could, to subsistence. It's 393.1700.1, and then it's 2 or 3. And let me figure this out. It's rather
Do you have a line number for that?
a line number from the statute.
The online version is what I'm looking
Oh.
at. If you don't,
I
that's
don't
fine.
know. My online version didn't have line numbers. When it printed out, at least it didn't. It's, I'm looking at the subsection 3 that refers to what the commission orders, is proceedings on excuse me, proceedings on a petition submitted pursuant to this subsection shall be disposed of. That's A. Then C says a financing order issued by the commission after hearing to an electrical corporation shall include the following elements. C says a finding that the proposed structuring and pricing of the securitized utility tariff bonds are reasonably expected to result in the lowest securitized utility tariff charges consistent with
Can you,
market.
can you lean forward into the mic again? I'm sorry.
Consistent with market conditions at the time the securitized utility tariff bonds are priced and the terms of the financing order. Are you generally familiar with that, Mr. Davis?
Yes.
Now, how, in your estimation, would the commission's order find that the structuring and pricing of the bonds are reasonably expected to result in the lowest securitized utility tariff charges? How would that?
Sure. The involvement of the designated rep with financial advisors, a finance team, some involvement of commission staff representatives throughout the structuring, marketing, pricing process, including, from the very early stages at the underwriter selection process through the ultimate pricing of the bonds is appropriate in order to provide some degree of oversight, input, collaboration to the utility on what's necessary to ultimately achieve the lowest cost, making sure that the structure is designed to bring in the lowest cost pools of capital possible, that the marketing process is sufficient and provides investors enough time and information to do their work to achieve the lowest price, and ultimately that pricing benchmarks are appropriately utilized and that the pricing process is designed to achieve the lowest possible cost. So involvement throughout the post-financing order pre-issuance process, I believe, is appropriate to achieve that requirement.
Thank you. And if I could also direct your attention to subsection 23B, refers to, or it states that in performing its responsibilities under this section, in approving subject to conditions, or rejecting a petition for a financing order, the commission may retain counsel, blah, blah, blah. But I noticed there that this subsection contemplates that the commission could approve the petition for securitization subject to conditions. Would you agree with that statement?
Yes.
And what type of conditions do you believe could be appropriate in approving the financing? Let me rephrase it. You mentioned in response to Mr. Zobrist that the statute allowed the commission to some flexibility in determining the role of the designated representative. Is that the section you were referring to, or one of perhaps the sections you were referring to, that allows the commission to condition its order in this proceeding and provide for duties of a designated representative?
Yes, I believe what you touched on Section B is relevant. Section C, in terms of achieving the lowest cost, is relevant. And I think the last section of Section H that indicates the financing order may provide additional provisions related to the issuance advice letter process as the commission considers appropriate and are not inconsistent with this section, are also informative.
I believe you said in response to Mr. Zobrist that the role of the designated representative has not been defined. And were you referring to has not been defined in a financing order?
Correct, the financing order, exactly,
Since the financing order has not yet been issued,
correct.
yet the commission is free to define the role of the designated representative in the financing order as far as you're aware.
Yes.
In response to the, well, let me stick with financing order for a second. There's lots of things that's in a financing order, correct?
Yes.
Are you familiar with the, prior to the submission by the parties of the non-unanimous stipulation that Mr. Zobrist mentioned, are you aware that the commission had ordered staff to submit a proposed financing order at the time staff files its initial brief in this case?
Yes.
And are you aware that under the terms of the non-unanimous stipulation itself that provides for the parties to the stipulation to provide for lack of a better term, that stipulation does not use this term, and so I want to say that up front so Mr. Zobrist doesn't scream. But for lack of a better term, the parties are to submit like a joint financing order in conjunction or in compliance with the stip and the statute,
Yes, that's my understanding.
and that will be done, or it's intent for that to be done at the time of the filing of initial briefs.
Yes.
So either way, whether you're talking with or without the stipulation, is it your understanding that it was always staff's intent to file or submit a proposed financing order for the commission's consideration?
Yes.
You mentioned the review of upfront and ongoing costs by the designated representative. What sort of costs are we talking about there? I guess there's two separate types, right? We have upfront and then we have ongoing, right?
Sure. The upfront cost would consist of items such as, I think the largest item in there is typically the underwriter fees, legal fees, rating agency fees, so various items that go into the issuance itself. It would also include commission advisor costs and other items that go into the balance that's ultimately securitized. The ongoing costs would be amounts that would be collected every period through the charge, and would include items such as the servicer cost, administrative fees, accounting fees, rating agents, ongoing rating agency fees, to name a few of the costs that make up large portions of the ongoing costs.
Okay, thank you. The judge asked you some questions about whether multiple series of bonds should be issued or could be issued. And he also mentioned that somewhere in Mr. Lund's testimony, perhaps also in yours, the concept of multiple tranches was discussed. Can you distinguish there between multiple series of bonds and multiple tranches of bonds?
Sure. So multiple series would be going to market multiple times and incurring each of those cost items under each of the different series. Once a series is structured, within that series and within the defined cash flow life, so 15 years estimated in this instance, the cash flows can then be divided up into multiple tranches. Here, there's been discussion around 2 or 3 tranches of bonds. And what that does is creates different pools of investor capital interested in buying the bonds. So the ratepayer sees one effectively levelized payment over the 15-year period. They pay the same amount each period. The tranches, you may have a 5-year tranche, and a tranche that's midlife and a tranche that's the back end of the 15-year period, where you attract short-term investors to buy into the short-dated tranche and investors that have a longer-term investment horizon to invest in the longer-dated tranches. So it provides for a wider pool of investors to participate in the issuance and can help drive lower cost relative to investors collecting their payments over a 15-year period. It looks a little bit more like what investors are used to seeing.
Is there an accepted definition of the term tranche that we could use, or you could give us, or is that perhaps not subject to definition?
I think I'd define it as a subset of the cash flow stream. A securitization of a subset of the cash flow stream. But I'm sure I could provide a better definition with a little more time.
Okay, sorry, yeah. You also mentioned in response to the judge, the issuance advice letter process. Can you explain that generally, the issuance advice letter process?
Sure. So because the terms of the ultimate financing are unknown when the financing order is approved, commissions in many instances have required a process which culminates in an issuance advice letter being provided to the commission, with a period of time for the commission to reject that issuance advice letter to the extent it deems appropriate. It's very uncommon for issuance advice letters to ultimately be rejected. It could be catastrophic from a capital markets perspective if an issuance advice letter is ultimately rejected. And so a broader process is common to ultimately inform the issuance advice letter, reviewing all aspects of the structuring, marketing, and pricing, and other elements that inform the costs that ultimately will end up on the ratepayer bill. The issuance advice letter itself will include the final details of the securitization itself. So that would include items like the repayment schedule, the interest rate, the schedule of the actual amount of upfront and ongoing costs, to name a few of the items that would be in the ultimate issuance advice letter.
If the designated staff representative participation in the process is limited to advising the commission whether to approve or disapprove the issuance advice letter, would that be problematic?
Yes, if ultimately the designated rep simply receives 2 weeks or some period prior to the issuance advice letter being finalized, a draft that has all the terms, has the tranche structure, has what's ultimately fed into where the utility is at on what will be issued, and doesn't have any ability to gain information throughout the process on the way to achieve the best, structuring, marketing, and pricing, and ability to provide input and collaborate with the utility during that process, they could end up in a situation where it's probably not the best structure, marketing, and pricing that ultimately could have resulted in the lowest cost. But in a world where if that issuance advice letter was rejected, it would be catastrophic from a capital market perspective and very difficult, put the commission and the designated rep in a very difficult position. And that's why one of the best practices that we've seen across the country is the designated rep or finance team review process in advance of it. So we're not in a world where the issuance advice letter is delivered and the commission has 4 days after pricing, or I believe under the statute, 4 days after delivery of that issuance advice letter to ultimately approve or reject the advice letter.
And you say you have seen that in other jurisdictions?
Yes.
Is it common in other jurisdictions for the staff designated representative or whatever it's called in those other jurisdictions to be involved in throughout the process rather than waiting until the end of the process?
Yes.
I think that's all I have, Judge. Thank you.
Mr. Davis, you may step down.
Thank you.
It is 11:02, and we've been going for quite a while without a break, so why don't we all come back at 11:30, and then we'll do at least one OPC witness and see where we are in relation to lunch. So, be back at 11:30, and we are off the record. OPC? Well, let me clarify. Staff, you don't have any further witnesses, do you?
No, Judge, we've had all of staff's witnesses take the stand. Thank you.
Thank you. OPC, you may call your next witness.
Thank you, Your Honor. The OPC calls Mr. David Murray to the stand.
And Mr. Murray is appearing remotely. Mr. Murray, would you raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth?
I do.
OPC, you may inquire.
Good morning, Mr. Murray. Please state your name and spell it for the record.
My name is David Murray. Last name is spelled M-U-R-R-A-Y.
By whom are you employed and in what capacity?
Employed by the Office of the Public Counsel as a utility regulatory manager.
Are you the same David Murray who caused to be prepared rebuttal and surrebuttal testimony in this matter?
Yes, I am.
Do you have any corrections or additions to your written testimony that has been pre-marked as exhibits 203P and 203C for rebuttal testimony and 204P and 204C for surrebuttal testimony?
I do not.
If I asked you these same questions today, would your answers be the same?
Yes.
Are those answers true and correct to the best of your knowledge?
Yes.
Your Honor, I offer exhibits 203P, 203C, 204P, and 204C for admittance and tender the witness for cross.
Any objections to admitting 203P, 203C, 204P, and 204C onto the hearing record? 203P, 203C, 204P, and 204C are admitted onto the hearing record. Any cross-examination for this witness from MECG?
Yes, Your Honor.
Go ahead.
Good morning, Mr. Murray. You're aware that there's been a stipulation and agreement filed in this case, correct?
Yes.
And within that, are you aware that OPC carved out a few issues that remain disputed? And one of those issues is carrying costs?
Yes.
Can you tell me what the main difference between OPC's position on carrying costs and what is contained in the stipulation agreement?
The main difference is after the fuel adjustment clause period, the stipulation and agreement entered into, and filed, and I guess agreed on this part was, for staff and the company, is after the fuel adjustment clause period, they increase the carrying cost rate applied to the balances. And I think that rate is 5.06 based on an embedded cost of long-term debt from 2018.
And
My recommendation is to continue to use short-term debt costs incurred by the company until such time as the bonds or the securitized bonds are issued.
why do you believe the short-term debt is the appropriate amount to use?
Well, first, and from a financial logic standpoint, that it's highly unlikely that a company is going to issue a 2 or 3 year bond. I mean, there are exceptions to finance these costs before they issue the securitized bonds. And so I would say that I think that is a prudent and customary practice that I would expect. But in the instance of Evergy Missouri West, in the Evergy Missouri West rate case, in discovering that case, I found that they carry quite a bit of short-term debt on their books and have indicated one of the primary reasons is the Storm Uri asset.
So if I'm understanding that, you're recommending short-term because that's what the company has incurred while carrying this debt for Storm Uri?
Yes.
No further questions, Your Honor.
Any questions from the commission staff?
No, Judge, thanks.
Any questions from Evergy?
No questions, Judge.
Any commissioner questions?
No questions, Judge.
Thank you, Chairman. I have just a few short questions for you, Mr. Murray.
Sure.
Has Evergy issued long-term debt since 2020?
Evergy, Evergy has it, but they have many companies on Evergy Missouri West. I'm not sure if you're referring to Evergy, the holding company, or Evergy Missouri West. So can you clarify that for me?
Well, to the best of your knowledge, why don't we go through both Evergy Metro and West? Let's start with West. Have they issued long-term debt since 2020?
Evergy Missouri West has, and I think that occurred at the beginning. It's because I know it's captured in the true up of the financial data, financial information in the pending general rate case, and I think it occurred sometime in the first quarter of 2022.
Did Evergy West issue any long-term debt in April of 2021?
I don't believe they issued any long-term debt in April 2021.
You believe it was 2022?
Yes, it was in the front. I know it's in the true up because it's an embedded cost of debt, and there was in the concurrent rate case, there was anticipation of issuing additional debt by Evergy Missouri West, and it did do so definitely in the first quarter of 2022.
What about Evergy Metro?
Evergy Metro, I don't remember right now.
Prior to 2022, does the long-term issuance, does Evergy West long-term issuance of debt correspond or cover the period that would cover Winter Storm Uri costs?
There were no long-term debt issuances subsequent to, I say subsequent, at the time of the Storm Uri costs throughout 2021. And I said that proves out in the analysis that I did in the Evergy Missouri West general rate case.
Is anybody proposing to use long-term debt in this case?
Yes.
Does it matter that the long-term debt issuances weren't specific to the Winter Storm Uri time period?
Yeah, I don't believe so because I still, in my position, my view is that in anticipation of securitization, you're not going to issue, a 10-year mortgage bond, or I guess they're issuing mortgage bonds now. That used to be unsecured debt for a asset that was funded and will be refinanced with securitization bonds by January 2023. That just wouldn't be a financial practice that I would consider to be logical.
Okay, thank you. That's all the questions I have for you.
Thank you.
Any questions from MECG based on bench questions?
No, thank you, Your Honor.
Any questions from the commission staff based on bench questions?
No, Judge.
Any questions from Evergy based on bench questions?
No questions, Judge.
Any redirect from public counsel?
One moment, Your Honor. Mr. Murray, in response to questions from the bench, you discussed long-term debt. Despite the issuance of long-term debt, has Evergy Missouri West continued to carry short-term debt specifically related to Storm Uri?
Yes, they've affirmed that continuously throughout the rate case, the Evergy Missouri West concurrent rate case that's pending right now.
And could you explain how you know that?
Through just discovery of looking up at their outstanding balances of short-term debt, which is actually is composed of commercial paper borrowings, which is Evergy Missouri West issuing debt directly to the third party of debt markets, but also through the receipt of money pool borrowings through their internal money pool, and I know that Evergy Metro has lent at times, I think around $200 million or so to help fund our support the Storm Uri costs. But of course, and one thing that is important to note is that in my understanding is Evergy Metro is only receiving interest on that loan at a commercial paper rate.
Mr. Murray, you also mentioned it not being logical to issue long-term debt prior to securitization. Could you explain why that is?
I mean, the company is anticipating that it's going to be able to refinance this obligation through securitization. I mean, that's the whole reason why we're here, and I just would not, if they had expected it to continue to be part of their corporate financing obligations, then they would refinance it, potentially with a current balance of their capital structure. But that's not that's not what they expect. They expect to be able to issue securitized bonds, and that'll refinance, the current financing that's on their books.
Okay, shifting gears a bit here, Mr. Opitz asked you about the non-unanimous stipulation and agreement and mentioned that OPC carved out a few issues. Do you remember that?
Yes.
Are you aware of any other financing issues on which OPC takes a different stance than staff and Evergy Missouri West as reflected in that stipulation and agreement?
I mean, obviously, the primary was the short-term debt. The biggest disagreement I have with the use of long-term debt is it's from 2018. It has no connection to what their current long-term debt costs are. So it just makes no sense. I mean, that long-term debt was in existence before Storm Uri. It just has no economic connection.
No further questions, Your Honor.
Thank you, Mr. Murray. You're excused.
Thank you. Have a good day.
OPC, you may call your next witness.
The OPC calls John Riley to the stand.
Mr. Riley, would you raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth?
Yes.
Please be seated. You may inquire, OPC.
Good morning, Mr. Riley. Please state your name and spell it for the record.
My name is John Riley, R-I-L-E-Y.
By whom are you employed and in what capacity?
I am the supervising auditor for the Office of Public Counsel.
Are you the same John Riley who caused to be prepared rebuttal and surrebuttal testimony in this matter?
Yes, ma'am.
Do you have any corrections or additions to your written testimony that has been pre-marked as Exhibits 205P and 205C for rebuttal testimony and 206 for surrebuttal testimony?
No, I do not.
If I asked you these same questions today, would your answers be the same?
Yes, ma'am.
Are those answers true and correct to the best of your knowledge?
Yes, they are.
Your Honor, I offer Exhibits 205P and 205C, as well as 206 for admittance, and tender the witness for cross.
Any objections to admitting 205P, 205C, and 206 onto the hearing record? 205P, 205C, and 206 are admitted onto the hearing record. MECG, do you have any cross-examination for this witness?
Yes, Your Honor. Mr. Riley, you're aware of the stipulation that was filed in this case, correct?
Yes, sir.
And one of the issues remaining to be determined is how to treat taxes. Is that right?
That's correct.
What is the main difference between what the company and staff propose and how you would propose to treat taxes?
Well, what company and staff have proposed is there was a tax break, a tax reduction of about $72 million, and the company and staff would like to separate that and leave that retained by the company, and then file securitized bonds for the entire amount of the fuel and purchase power and finance costs and everything else that's included. The witness the other day, Ms. Hardesty, had stated that they don't have to pay back the tax reduction, and that the financing for the bonds is built into the bonds, whereas what public counsel would prefer to do is to recognize the tax break and reduce the total cost by that amount, and then use that total cost in securitization without including taxes built into the securitized amount, because taxes can be added on to the back end. By doing that, you save $30 million without having to finance the taxes built into the securitization amount. So that's basically the difference.
You were listening to the testimony of staff's witness, Ms. Bolin, on this issue yesterday, correct?
Yes, sir.
And if I'm remembering right, she testified something to the effect of that the taxes should be treated as a deferred to a liability, tax liability. Am I remembering that correct, or characterizing that correctly?
I think she stated that that the deferred tax liability was the mechanism to essentially refund money back to ratepayer.
Do you agree with that approach?
I don't think that's correct.
Why is that not correct?
One is the company received the tax break in 2021, and basically, when they filed their taxes, they received 72 million, give or take, 72 million right up front, and to offer to return money back to the ratepayer over 15 years just doesn't seem like an equitable solution to that. And in my calculations in Sir rebuttal and in my schedule, I point out that only out of 72 million, only 48 million gets returned to the taxpayer, the ratepayer anyways. And then I also have a slight problem with actually calling it a deferred tax, because originally in my Sir rebuttal, I have a data request in here that Melissa Hardesty pointed out that they created a deferred tax liability in anticipation of the FAC. And that would have been the appropriate bookmaking, because the FAC, they collected, they got their tax break in 2021. And let's just say that through the FAC, they would have collected all their money back in 2024. That would have created a deferred tax reversal. So you would have reversed that book entry. But when you're talking about securitization, there isn't any deferred tax. I mean, she admitted it on the stand that they don't have to pay back the 72 million. So if there's not a payback, then we don't have a deferred tax. You may say there's a deferred liability, but there's really no deferred tax at all. So to say it's going to come back, I'm not really quite sure how that's going to happen.
So relating to taxes, when the company is collecting the money from customers, whatever charge is ultimately authorized, will there be an income tax that would be collected from customers as a result of that?
The way I understand the statute, and this is the way I've always thought it for the past two, the two securitization cases, is the tax is going to have to be collected. And it's going to have to be collected from the customer, and as far as I'm concerned, at the billing. I certainly don't want it to be included in the securitization. So as far as my understanding of the statute, they have to collect the tax at the billing. So my argument, of course, as you asked me before, is I want to recognize the tax break and reduce the amount of the securitization, because I don't want any taxes built into that, because, after 15 years, you're paying $30 million extra interest. So they should have to pay the tax, on the back end, as I would refer to it, on the back end, not on the front end.
That's all I have. Thank you.
Any cross-examination from the commission staff?
No.
Any cross-examination from Evergy?
No, thank you, Judge.
Any commissioner questions? Hearing none, I have a few questions for you, Mr. Riley. Now, you've read Ms. Boland's Sir rebuttal in regard to the income tax issue, correct?
Yes, sir.
And she proposes to treat the income taxes associated with Winter Storm Uri through a regulatory liability and reduce rate base, to reduce rate base, and that staff will not include the securitization bond payments in revenues for counting the cost of service in a gentle rate proceeding. Does that satisfy your concerns?
No. As I said before, I don't believe there is a deferred tax. There may be a liability, and you can offset rate base with it, but we need to keep in mind that the company's going to float bonds, and currently it's going to be about $300 million. And they also have $72 million of interest-free money they collected in 2021 from the tax break. So it sounds nice that we're going to give back $48 million out of 72 to the ratepayer, but when you think about it, we've got $372 million to put into rate base. Kind of offsets a puny little $72 million liability pretty quick. So what we're trying to do here is make this as painless for the ratepayer as possible, and that it's just not an equal exchange. I mean, you're paying it back over 15 years. Why? I mean, the $72 million came up front, so why don't we take advantage of that and offset what they're going to have to pay for 15 years instead of trickling back this money over 48, like I said, I calculated it's $48 million, so they're not even getting the full 72 back. And like I said, I use 72 because it's how I'm not saying that's exactly what it is, but it just doesn't seem like an equitable way to help the ratepayer. I don't think it's the best way.
I've had a real difficult time wrapping my head around this because this is not a forte of mine, but to read your testimony, it just seems like you and Ms. Bolin are pointing fingers at each other and saying, well, the other person's wrong. In your testimony you just gave, you used the phrase after describing how staff had proposed to do this, you said OPC would prefer. To me, that would seem to imply that you have two acceptable methods and you just think yours is better for certain reasons. Is that correct or incorrect?
Both methods could be done. I mean, both. And I guess it's an accurate statement from you. I don't think. I think we need to take care of this up front, and staff wants to float it over 15 years. So yeah. I guess you could say there's two ways, and I do prefer to take care of it up front instead of that way staff intends to do it.
Now, you said that the way that you propose doing it, you believe results in a savings of $30 million. Is that correct?
Yes, sir.
What, to the best of your knowledge, are staff's reasons for wanting to do it in a way that, in your mind, would add $30 million to the cost?
I don't really understand why they're going that way. They've taken the side of what the company wants to do. So I'm not real sure, other than Melissa Hardesty said, that we aren't going to charge any tax on the billings, but when it's all said and done, even the other day when I finally heard what the costs were in the stipulation and agreement, I actually just sat down and worked out the numbers. I'd worked out some numbers in my exhibit in server rebuttal, but I actually worked out and put them next to each other, what the company is doing and what OPC would like to do, and it still comes out to be $30 million. When you and I can hand this out, but basically you got 298.9 in upfront bond costs, and when it's all said and done, you're going to have total payments of $425,462,760. So if you take the 72 million off of that, you start with a balance of 227 million, and you work out to a total of $324,032,400. So that's 101 million less. Now, they aren't charging tax, or at least they're saying they are not going to charge tax. We've already pointed out in statute we think they have to, but they aren't going to charge tax. Now, when you figure up the tax on $227 million, it's about $54 million. Now, of course, you gross that up. It ends up being about $71 million. So when you add it all together, the customer is going to have to pay $395 million, and in staff and companies, they're going to pay $425 million. So it's a $30 million difference. So, and I argued in SIR rebuttal that you shouldn't include the tax in the bond amount because that's going to end up costing you another $30 million in interest. It's on Schedule 2 on the right-hand side where I calculated, the bond payments on the $72 million. When you add it all up, your bond payment for $72 million is over $102 million. Why do that? Well, you don't have to. You don't have to include it in the bond. You can tax it on the back end, so you don't have interest building up on this. You just charge the tax. So you don't have to do it the way they want, and I'm not really sure why they want to do it that way, because it seems obvious to me that $30 million is a cheaper way to go.
Thank you for breaking that down for me. So it appears that you have two concerns with staff's approach here, and it appears that one is the 30 million, and the other is the return of ratepayer benefits over time. Would that be correct?
Yes, sir.
And you may not know the answer to this. To the best of your knowledge, under either method, does the net present value make this feasible in terms of benefiting the ratepayer?
Well, I mean, Ms. Boland pointed out that the way they were looking at it benefits the ratepayer. And I'm just saying that that's fine, it does, but it doesn't benefit it as much as what OPC is pointing out. I mean, you might want to look at the net present value of $48 million, and I don't know what that is, 20 million or something like that. But however, I'm pointing out is that they're going to have $372 million to stick into rate base. That is certainly a heck of a lot more money than 48 million. So that kind of gets lost, to say they're getting a benefit. I'm not, you've got an extra $72 million out there that the company's never going to have to pay back. I mean, Melissa Hardesty said it, I said it in testimony, and I've been saying this for 2 cases now, is this tax write-off is a freebie. It doesn't go back. It's separate from rate making now. The way securitization moves, not in FAC, but in securitization, it is separate from a case, and it's also separate from the SPE. And I was a little confused when originally when she said we don't have to pay back the reduction, but the taxes are built into the bond, and then once I realized what was going on is of course they've always got this extra 72 million to do what they want with, that I realized how much it was going to cost.
Thank you. Those are all the questions I have for you. Any questions based on bench questions from MECG?
No, thank you, Your Honor.
Any questions based on bench questions from the commission's staff?
Since I don't know what Mr. Riley's talking about anyway, I'd better not ask any questions. Thanks, Judge.
Any questions based upon bench questions from Evergy?
No, thank you, Judge.
Any redirect from public counsel?
Yes, Your Honor. Mr. Riley, throughout your answers, both from the bench and to Mr. Opitz's questions, you mentioned a deferred tax. Could you explain what a deferred tax is?
Well, as you know, the word deferred means to be, to later, and deferred taxes are where you get your tax break now. So to put it in terms we kind of understand, accumulated deferred income tax, we know is you get this big depreciation up front, so you get a tax break. But we know as time goes by, the depreciation shrinks, so it comes back around, and essentially sooner or later you're going to have to pay the taxes back. But and that would have been the same way with going through the FAC, as Melissa Hardesty had stated in the answer to the data request I put in here. They set up a deferred tax for FAC because eventually 2 or 3 years later they were going to have to pay it back. But with securitization now, we've taken what would have been the cost, which we're going to get recouped in the FAC. They aren't getting recouped anymore. They're going into tax-free, they're not tax-free bonds, but the bonds themselves aren't taxable. So, I mean, the proceeds from the bonds aren't taxable. So when it went into there, the tax break was left out by itself, and it never has to be repaid. And just to make sure I'm clear on that, with the inclusion of taxes within the bonds themselves, there's no deferral going on within the bonds, and SPE doesn't have a deferred tax either. There's nothing in there also because the money is right there.
So just to clarify, deferred taxes are deferred because the taxes need to be paid back. That's the deferral.
That's correct.
Okay, could you also explain what a deferred liability is?
Well, that would be rather similar. I mean, deferred tax is a deferred tax liability, whereas the liability is something that needs to be repaid in the future. It's just, are we talking about taxes or are we talking about something we owe back? So a liability is a deferred liability is something that needs to come back eventually and be repaid to, it could be repaid to a lot of people. Deferred taxes are paid to the government, but a deferred liability will roll back this way. My problem with the whole thing is if you don't have to pay back the deferred tax, if you don't have to pay back the tax benefits, and everything else is now put over in the SPE, there's nothing to come back. There is no liability. Everything else is separate from rate making. So I'm not sure why staff seems to think that there's going to be something out there that's going to roll back over 15 years to the ratepayers.
You mentioned that there is no tax. You mentioned that there is no deferred tax to the SPE. Is that correct?
Yes.
Does the SPE pay income taxes?
Well, as Ms. Boland pointed out yesterday, they're all part of Evergy Inc. So to say that SPE is going to pay tax isn't correct. They're all in the same bucket with to make up Evergy Incorporated. So but as as each division figures out their income for the year, they would end up funding into the tax agreement. They would end up funding their portion in there so that Evergy can pay their taxes with the Evergy Inc. can pay their taxes. So they'll calculate, what portion is theirs, if that answers the question.
So to clarify, income taxes will be paid on the revenue collected to service the bonds.
Yes.
Now, where do you believe it should get the money to pay those taxes?
Well, it's going to have to come from the customer. That's my understanding of how the securitization statute reads.
Could you explain your understanding of the statute?
Let's see. Well, what,
Judge, I'm sorry, I'm going to object. This is beyond the scope of bench questions.
OPC response?
We'll move on, Your Honor. Mr. Riley, in questions from the bench, you were asked about there being two acceptable methods. Do you remember that?
yes, ma'am.
Do you believe that staff's method that does not include taxes in the securitized utility tariff charge complies with the statute? And by statute, I mean the securitization statute, 393-1700.
Could you say that question again, please?
Do you believe that staff's method that does not include taxes in the securitized utility tariff charge complies with the securitization statute?
Now I understand. No, I believe that the charges have to be, or the taxes need to be charged at that point. Let me restate that I said charges needed to be charged at that point. What I mean is the taxes need to be figured and included so that they are they're included in the charge that the customer is going to see each month. I think we'll go with that.
Also, in questions from the bench, you were quoted a passage from Ms. Boland about including taxes in revenue. If taxes are recovered through the securitized utility tariff charge on customers' bills, does that mean they will be in revenues?
Okay, so if I'm understanding the question, in the charge, you're going to have your payback of, bonds and interest and any other cost, plus the taxes, they're all going to be built in together. So if I'm understanding that correctly, then it's the whole thing is revenues.
To put my question a little bit more simply, will the amount collected from the securitized utility tariff charge be put into revenue requirement?
Oh, according to, I think Ms. Boland's testimony and I think some data requests, it does not fall under revenue requirement. It's going to be a separate, from what I understand, a separate amount through the SPE, which isn't going to be in typical rate case revenue requirement.
Now, Mr. Riley, several times throughout your testimony, both in response to bench questions and in questions from MECG, you mentioned that customers save $30 million under the method that you have described. Do you remember that?
Yes, ma'am.
Your Honor, I would like to mark as an exhibit, Exhibit 209. Mr. Riley, could you explain what this document is?
Well, once, the numbers were floating around and for, several weeks about what was going to be included and Sir rebuttal testimony I had.
I'm sorry, I'm gonna have to interpose an objection here. We're getting testimony now as to the contents of this document, and it's not in evidence. We've never seen it before. We had no chance to cross on it or review it prior. No reason's been given for its inclusion at this moment or how it has anything to do with bench questions.
Would you like to complete your foundation?
Yes, Your Honor. So, Mr. Riley, I think you were trying to say that this is the calculations that you've walked through. Is that correct?
That's correct. This is how I came up with the 30 million that I mentioned to the judge.
And is this a faithful representation of the math that you have described?
Yes, ma'am.
Is there anything else you'd like to explain about this document?
Judge, this is going too far. He creates this document down in his office. You asked him something that did not relate to this document because you'd never seen this document. He dropped some word in there about, I came up with $30 million. Okay, fine, you got $30 million difference. Then they try to put this thing in after the fact to support his claim. I mean, he was never asked about this document. He couldn't have been asked about this document because the document wasn't even in evidence. And I mean, this is way beyond the scope of any cross from Opitz or you or, even, Mr. Kleiser down there. This is just beyond the pale at this point, Judge, and I have to object to continuing this line of questioning and object to exhibit number 209.
OPC response?
Your Honor, I believe that redirect doesn't relate solely to questions from the bench, and Mr. Riley has mentioned a $30 million savings in his answers both to MECG's questions and Your Honor's questions. And Your Honor specifically asked Mr. Riley about the $30 million savings, and he was explaining how he arrived at that answer. And we are simply offering this as a demonstrative of the math.
Mr. Riley, are these numbers contained in your testimony?
These numbers are correspond with the 30 million total interest paid by the, if you look at my Schedule 2 on the right side, I talk about the interest you have to pay on the $32 million. So yes, it corresponds to something in my testimony.
I'm going to overrule the objections. It's demonstrative. I'll take it for weight.
Your Honor, I would like to offer Exhibit 209 for admittance into the record as a demonstrative.
Any additional objections?
Well, I think so, Judge. Earlier, an exhibit was entered as a demonstrative, and Your Honor then admitted it into the record as evidence instead. And so we do object for all the objections stated, and we'll join staff's objections.
That'll be overruled. Exhibit
It's Exhibit 209, Your Honor.
I understand. Would you like an opportunity to cross the witness on it?
Judge, our experts are not here to look at this exhibit. We're unable to confer, and I've just seen it for the first time, so at this time, have nothing to say about it.
Then, as I previously stated, the objections are overruled, and I'll take it for weight as a demonstrative.
We have no further questions, Your Honor.
Exhibit 209 is admitted onto the hearing record. And you said you had no other questions?
That's correct.
Do you have any further witnesses to call at this time?
No, we do not.
Is there anything else that the commission needs to take up at this time?
Judge, I'd like to confirm that all the company's exhibits have been offered and accepted into evidence, all the pre-filed.
We can absolutely do that. Do you want to go through it by exhibit number?
however you'd like to do. I just wanted, if you've got a list, I think we have a list that indicates that it's all been accepted into evidence. So if that's confirms, is that consistent with the bench?
I've been keeping a list as we go along. If you want to ask me which particular exhibits, whether they've been admitted, I can tell you. Oh, I'm sorry, Mr. Mr. Riley, you're excused.
I guess our exhibits were 1 through 19.
What's Exhibit 5?
Exhibit 5 was the SIR rebuttal of Melissa Hardesty.
Hardesty, I see it now. Okay. And ending with 19, IRS procedures?
Yes.
Okay. I have 1 through 19. If you want to inquire in particular as to, there are a lot of them have public and confidential versions. If you want to inquire specifically as to those, I'm happy to do so.
I don't think there was any distinction on the record on those. So if you, that's your list, that's ours too. Thank you very much.
Of course. Is there anybody else, any other party that would like to do that? I'm happy to do that.
Well, I might as well, Judge. I had 100 through 106. I show them as all being marked and received. And some of them were confidential, some of them were public, or were both confidential and public. But if you just 100 through 106, I don't think there was a distinction between the public and the confidential.
And that's ending with 106 Davis rebuttal?
Yes.
Yes, I have all of those.
Thank you.
OPC?
Your Honor, our pre-filed exhibits were 201 to 208, and some of those were public and confidential.
$209.
The
Oh, those are the
pre-filed
pre-file, okay.
was 201 to 208.
I have all those and 209.
Do you have 200 as well?
The prudent investment test?
Yes, the NRRI report, the prudent investment test.
I do.
Okay, thank you, Your Honor.
MECG?
I didn't have any pre-filed testimony, Your Honor, but my notes showed that I had admitted all of the exhibits I offered. I believe it was 300 through 302.
Yes, I have those. And those, I believe, are all the parties we have here at the moment, so I can't go into Nucor Steel or Velvet Tech. Right now, I have initial briefs due August 31st. I have responsive briefs due, or reply briefs, due September 12th. And transcripts, as I currently understand them, will be available on the 18th.
Judge, I may regret asking this, but that's just the kind of guy I am. Regarding the briefs, my question is, because the parties submitted a stipulation which didn't cover all issues but covered a lot of issues, typically in commission proceedings, what we would do would be to just brief the issues which were not resolved by the stipulation. However, during the hearing, you have basically assumed the stipulation had not been filed in regard to a lot of the questioning and in regard to a lot of the issues that were shown on the issues list, and perhaps also in the statute, I forget. My question is, for purposes of the briefing, do we brief it like there's been a stipulation, or do we not brief it like there's been a stipulation, or, God forbid, do we do it both ways?
I would brief your full case, and if you have anything you want to say about the stipulation in your brief, you're welcome to.
Both ways, okay.
Yes.
Thank you. Oh, I believe Monday I also asked something about the order that you issued prior to the stipulation being filed about the submission by staff of a proposed financing order was to be filed with the staff's initial brief, and then I assume that order is still.
You asked if there were going to be 10 days since it was filed. It was filed, I believe, last Wednesday, which makes today the 8th day.
Right, so responses would be due Monday under the commission rules because technically it would fall on Saturday.
Yes, unless otherwise designated, Monday is correct.
Monday, right, okay. Thank you.
Now, I discussed a number of, I'll address right now, I discussed a number of late filed exhibits that I requested in regard to two from, related to Evergy witnesses, questions I had for Evergy witness Ives. What I will call collaborative tariff that is not yet complete. I had asked for, I believe, Mr. Davis's work papers in relation to calculation of net present value. Any late filed exhibits, is the 11th of August reasonable to have those by?
That's next week.
That's 7 days away.
I honestly don't know in regard to that tariff. I think the parties had under the stipulation, I think the parties had provided that they would file that tariff by the 12th, unless something prevented it being filed on the 12th.
Okay, well, let's do the 12th with objections due on the 17th. Are there any other issues or anything that any of the parties want the commission to take up before we finally adjourn?
Your Honor, I just have a point of clarification. I believe you mentioned that transcripts were going to be ready on the 18th of August.
Correct.
In the procedural schedule, it has transcripts due on the 10th of August. I just wanted to clarify what that date was.
And was that in relation to an expedited transcript request of some kind?
I'm not sure, Your Honor. It's just what's included in the procedural schedule.
I've talked to the court reporter this morning. I don't think that the 10th is a doable date for the court reporter. Is that correct, Ms. Bench?
That's correct.
I believe in talking to the court reporter, the earliest I could expedite these two is the 15th. The 15th. Would the 15th be satisfactory?
That would be fine.
Okay, I will expedite transcripts to the 15th.
Thank you, Your Honor.
Thank you for bringing that to my attention. I was unaware of that off the top of my head.
You're welcome.
Is there anything else that needs to be taken up by the commission at this time?
One question, Judge, going back to your answer to my question about what do we brief? I think you said brief the entire case, but I assume that does not mean that a decision has been made by the commission to reject the stipulation that was filed Monday.
That is correct. No decision has been made by the commission yet regarding the stipulation in any way or form. It was my preference, given some concerns, that we proceed with a full hearing and get all the evidence on record. Hearing nothing else, I will adjourn this proceeding at this time, and we will go off the record.
Thank you, Judge.
Thank you, Judge.